Very warm good evening to all. The first topic we would like to discuss today is about arguments. Whenever your new friends will meet you, they will ask you, how do you argue in the court? And that is the basic question everybody will ask. They will never know that there is a cross examination. Maybe cross examination at least known to few people because of the Hindi movies now. That how the lawyers ask the cross. The main word they will ask you, do you argue in the court? How do you argue? या कभी friends बोलेंगे मुझे आपका आकर आपका arguments देखना है आप कोर्ट में कैसे बात करते हो. So argument is one of the important part of civil, criminal, matrimonial, company matters, any matters for that reason. So argument is one of the very important part, which is the integral part of the any trial. It may be any proceedings also before the court. So how you argue is going to make a lot of difference. But when you are new, it is really sometimes difficult to understand that how do we argue the matter. When I came new to the profession, I was always wanted what point I should take, the legal point or factual point. Now, this has been beautifully done in one of the judgment of Justice Chitre of the Madhya Pradesh High Court. It is a matrimonial dispute, but the way he has interpreted the sections, the factual position is very important. For me, to make you understand how do I argue, in whatever little knowledge I have gained in last 2 decades, I have always argued in nutshell, that is not in very detail. I've taken only a few minutes of the court. I won't take 3 days or 2 days or one day. It is not a disrespect to those lawyers who argue so long, but it is from my whatever cases I had, I wanted to argue to the point. One way to argue is to give written submissions, that is in writing. Whenever you want to put something very concrete, you feel that a matter goes in appeal, the court may not note down your points. You have fear that if there is a judgment after the arguments are over and judgment is going to take longer time, so it's better to give in writing. But there is a possibility like bail arguments you have to do on the spot, there is discharge argument on the spot. In such matters, you cannot always give written arguments unless the court suggests. There are some judges who say, don't give written arguments, I want to hear you. They actually want to ask some questions to you. That is the reason behind it. Now, what happens when you argue? The confusion remains whether we should argue on the law point or factual points, or we should also give any counter arguments answer also. The I would say the main thing about it is that you can part in three ways. One, that the what is the allegations against you, or what is the case. One. Number two, you can also give the in that same this you can give the factual position of the real case. What is your case? And thirdly, on the law point. So we divide it in three parts. First, what is the case filed? Number two, what is the factual position? And thirdly, law point. Because see, law point is always same. All the judges, all the courts knows it. But if you are unable to distinguish between the factual points, that is the what is the real case, why it has happened, and also what was the reason for the complainant has filed this case against you. There is a possibility it's a false case. See what happens in some time there is a dispute between two parties. One woman goes and file a case against the another neighbor that he has outraged my modesty, or he was stalking me, or he was just following me on the path, and she can file a false complaint. Now you have to bring before the court. There was already a dispute of parking in a cooperative houses society between two parties, and because of this, a scuffle happened between that, and this man went behind that woman, and he may be abusing or whatever it is, or he may be shouting at her, and this she has taken as a he was stalking me or some other way. Now you have to bring this factual position before the court that actually there was a some reason behind for filing that complaint, and it's a false complaint. It cannot be a because see if they are neighbors, they are staying there for years together. Now where is the question of outraging her modesty when they had stayed for years there, maybe 2 years, 2 decades, or maybe more than that, and they have never filed complaint against each other except on the parking issue. So you have to bring this. Now, after this is over, this I will just give an example. After this is over, what you have to bring to the court knowledge, that what is the definition of 354 Indian Penal Code? If it is stalking, stalking should be with some intention. If a see, yesterday we read about in the definition that if a police officer is stalking somebody, that he is following somebody, that is not a stalking. It is, there is a purpose behind it. Now this man went to speak something about the dispute. That is not a stalking. So here you have to bring out this thing before the court and put a factual position and say that the factual position once brought before the court does not fit into the definition of 354 Indian Penal Code, that is stalking. Now it may be an accident case, where accident case, what is the basic requirement? Negligence. I should be negligent. I'm just driving without any brake and I'm driving at a very fast speed and I'm rash. If the car is going at a slow speed of 20 near the, I would say, signal. Now this cannot be rash and negligent. If the car just stopped immediately and the man came rushing and he was just crossing and I have to put the brake immediately. Now this will never fall under the accident case. What is the definition in the accident case when we have to punish is 279, 337 and 338. You can read this definition. It is rash and negligence. The rashness of the car was coming in a full speed, maybe 100 to or 120, 150. And he was negligent. I was see, even a dog coming, even a person, old man coming, and I was negligent, didn't even put the brake. I didn't even take that person to the hospital. This is what you should know. If you are not aware about all these things, then what will happen? Then possibly that you may not be able to, you will bring the case filed against you, you will bring the factual position before the court, but you will not be able to bring out the definition before the court. So it is your duty to explain to the court that this is the definition of the rash and negligence, or this is definition of the Indian Penal Code 354, stalking a woman, outraging her modesty. And when you bring out this, then only the court will understand what is the legal definition. See, it's not that the court knows it, but then you have to bring out your case. It is your case, you have to study, you have to give the ready material to the court to show that actually there is a case which does not fit into the definition of 354 or the accident case 279, 337 or 338. 337 is like simple injury, and if it is a grievous injury, or if it is a fracture, then it is 338 of Indian Penal Code. So this is what you have to bring it before to the court. It is very important. Now I would like to take you to one judgment, which is Mamta Jaiswal's case, no necessary. It is a High Court case of Madhya Pradesh, but it is, if you read any maintenance case, it has been cited so many times, and Justice Chitra has written beautifully. He has, see, how should we argue any matter? He has actually said, how do we argue? In a para, I will be sharing with you, just a minute. This is a Madhya Pradesh High Court matter of year 2000. I'll be reading one para 6. Not even complete para. I'll try to read the little bit about it. You can read this judgment later on. But the main important part is section 24. In view of this, the question arises as to what way section 24 of the Act has to be interpreted. See, the word is interpreted. Whether a spouse who has capacity of earning but chooses to remain idle should be permitted to saddle other spouse with his or her expenditure. Whether such spouse should be permitted to get pendant like alimony at a higher rate from the other spouse in such condition. According to me, section 24 has been enacted for the purpose of providing a monetary assistance to such spouse who is incapable of supporting himself or herself. See, section 24 is gender neutral in spite of sincere efforts made by him or herself. A spouse who is well qualified to get the service immediately with less effort is not expected to remain idle, to squeeze out or to milk out. लैंग्वेज देखिए आप, इसमें कितना अच्छा यूज किया सर ने. to milk out the other spouse by relieving him of his her or her own purse by a cut in the nature of pendant light alimony. The law does not expect the increasing number of such idle persons who, by remaining in the arena of legal battles, try to squeeze out the adversary by implementing the provisions of law suitable to their purpose. In the present case, now you have to remember this. Just you have to mug up this case actually. In the present case, Mamta Jaiswal is a well qualified woman possessing qualification like MSc, MC, MEd. Till 1994, she was serving in Ghulam Nabi Azad Education College. It impliedly means that she was possessing sufficient experience. How such a lady can remain without service? It really puts a bug question which is to be answered by Mamta Jaiswal with sufficient, cogent, and believable evidence by proving that in spite of sufficient efforts made by her, she was not able to get service and therefore she is unable to support herself. A lady who is fighting matrimonial petition filed for divorce cannot be permitted to sit idle and to put her burden on the husband for demanding pendant right alimony from him during pendency of such matrimonial petition. Now read. Section 24 is not meant for creating an army of such idle persons. ध्यान दीजिएगा तो लैंग्वेज कितनी अच्छी यूज की. Section 24 is not meant for creating an army of such idle persons who would be sitting idle waiting for a dole to be awarded by her husband who has got a grievance against her and who has gone to court for seeking a relief against her. The case may be vice versa also. If a husband well qualified, sufficient enough to earn, sit idle, puts his burden on the wife and waits for a dole to be awarded by remaining entangled in litigation, that is also not permissible. The law does not help indolent as well as idols, so also does not want an army of self-made lazy idols. Everyone has to earn for the purpose of maintenance of himself or herself, at least has to make sincere efforts in that direction. If this criteria is not applied, if this attitude is not adopted, there would be a tendency growing among such litigants to prolong such litigation and to milk out the adversary who happens to be spouse, much dear but far away after an emerging of litigation. If such army is permitted to remain in existence, there would be no sincere effort of amicable settlements because the lazy spouse would be very happy to fight and frustrate the efforts of an amicable settlement because he would be reaping the money in the nature of pendant light alimony and would prefer to be happy in remaining idle and not bothering himself or herself for any activity to support and maintain himself or herself. That cannot be treated to be a goal of section 24. It is indirectly against healthiness of the society. It is enacted for needy persons who, in spite of sincere efforts and sufficient effort, are unable to support and maintain themselves and are required to fight out against the litigation, jeopardizing their hard-earned money income by toiling, working hard hours. So, what we see here is something which is actually saying that section 24 is not meant for the women who actually do not want to work or men who do not want to work and just to milk out money from the other spouse. It is saying that they should work for the actually work and they should demand only what is actually legal and just and reasonable. Here, a woman who is can find out the job, who is well educated, will not be allowed. Mamta Jaiswal, no case if you are appearing for husband or any section 24, where another person is asking some maintenance, it says that no person, no woman, in fact, it's gender neutral, that you can just sit down and say, I'm qualified, but I'm not interested in working. My husband should feed me. Or you can say vice versa. The husband is saying that I do not want to work. Wife wants divorce, let her give me maintenance. That cannot be done. And section 24 will, and this the way beautifully this is Justice Chitre has interpreted section 24 is very important. So do read this judgment completely. It is available on the net. Now we go to the part we will be reading today. Very interesting piece again. accused cannot be held
held
guilty solely on basis of refusal to undergo test identification parade. Supreme Court says so. The bench passed a judgment to this effect in a case involving the death of a law student for which the accused spent 12 years in prison. You can start, Parth.
Yes, ma'am. So the Supreme Court today held that finding a guilty cannot be solely based on the refusal of the accused to undergo a test identification parade. Rajesh, alias Sarkari, and ANR versus State of Haryana. While deciding a criminal appeal against a murder conviction, a three-judge bench of Justice D.Y. Chandrachand, Indu Malhotra, and Indira Banerjee noted that there is no specific provision either in the CRPC of or the Indian Evidence Act 1872, which lends the statutory authority to an identification parade. The fact of the present case involves a law student of Maharishi Dayanand University, Rohtak, who was allegedly shot at by a group of assailants near the university's law department. The victim was rushed to hospital but was declared dead. The father of the victim, who had witnessed the shooting, had stated that though he did not note the license plates of the motorcycles on which the accused fled, he could identify them if they were paraded
Parade.
before. The session court, by its judgment dated June 12, 2020, June 12, 2012, concluded that there was a ring of truth in the case of the prosecution, and the appellant were guilty of murder of the student. The appellant and the co-accused were therefore sentenced to imprisonment for life. Aggrieved by the judgment of the session court, all three accused filed appeal before the High Court of Punjab and Haryana. By a judgment dated January 17, 2019, the High Court dismissed the appeal, prompting the appellant to approach the apex court. One of the prosecution argument was that the accused had refused to undergo the test identification parade and that this was the proof of their guilt. However, the court analyzed a catena of judgments on the subject and stated that identification parades belong to the stage of investigation of the crime, and there is no provision which compels the investigation agency to hold or confers a right to the accused to claim a TIP. Noting that TIP is governed by Section 162 of CRPC, the court held that such a parade does not constitute substantive evidence and the failure to hold it does not ipso facto make the evidence of identification inadmissible. It further noted that some of the crucial evidence in the case suffers from serious infirmities and held that finding of guilt cannot be based purely on the refusal of the accused to undergo an identification parade, the judgment reads. The identification in the course of a TIP is intended to lend assurance to the identity of the accused. The finding of guilt cannot be based purely on the refusal of the accused to undergo an identification parade. A refusal to undergo a TIP assumes secondary importance, if at all, and cannot survive independently in the absence of it being a substantive piece of evidence. The court also noted that the evidence on record indicated that the deceased also had several criminal charges against him, some of which had ended in an acquittal on account of compromise. One of the appellant in the case was also a co-accused with the victim in one of the cases. After pursuing the other evidence in the case, the court held that when direct evidence of unimpeachable character is available and the nature of injuries is consistent with the direct evidence, the examination of ballistics expert need not to be insisted upon a condition to the prosecution proving its case. Noting that the prosecution cited a ballistic examiner as a witness and yet did not lead his evidence, and that there were discrepancies in the forensic science lab FSL report The court held that the accused would be entitled to the benefit of the doubt, holding that the prosecution failed to establish its beyond case reasonable doubt. The court acquitted the appellant of the offense. The acquittal comes after the accused spent 12 years in prison for the offense.
Thank you. This is Rajesh alias Sarkari and another assistant of Haryana. Now, this was a judgment on the test parade, that is IP parade, identification parade. In Marathi here, Maharashtra, we call it Orak parade. So this is very important when there is a possibility that a person who dies and other people see that somebody had come and have stabbed him or her. Now in this position, there is a possibility that the accused and the complainant do not know each other. Now police takes the identification parade. It's a very detailed subject. It cannot be explained in such a way, but I'm just giving an idea. And the identification parade, what happens, that Panchanama and that statement is very important. So identification law, if there are two accused, they will make 4 or 5 accused stand or 6 accused, and the complainant has to find out who is the person. It may be a rape charges, it may be a murder case, it may be a dacoity, or it may be a simple debt also. But then it is identification parade is also there. So always remember, this is also very important part of the criminal trial most. Now we go to the next part is the legal vocabulary as usual. They're not numbered today, but pay an attention to this. Tender and apology. These are very simple words today I'm taking, but actually, if you use it, it is going to help you. So when you speak before court, you don't say, I'm sorry, sir. You say, I tender my apology. Now, the Indian courts have always shown their magnanimity. Magnanimity, dayaluta, badapana batana. When anyone tenders an apology which is sincere and genuine. See how beautifully the sentence is drafted. Indian courts हमेशा है ना magnanimity. अगर आपने जगह apology बोल दिया, you tender apology, sincere. I couldn't make it on the last date. I tender my apology to my to the learned to the judge and also my learned to the court and also my learned opponent for remaining absent on the last occasion. So the Indian now court also shows their magnanimity. So magnanimity is a very good word if you use it when you are applying for bail. You say the court may show the magnanimity. Now makes or amends. So this is again a very simple word, makes and amends. You know how it is. It's a job of legislature to make and amend laws. The courts are just implementers. Who does the कानून कौन बनाता है? Legislature, parliament. The courts are just courts are implementers. Compelling in force करना, जबरदस्ती करना. The only compelling reasons to go to the court should be when the matter cannot be sorted amicably outside the court. The compelling reasons. Sometimes the petitioner is compelled to come before the court because she was unable to sort it out. This is contemplation. Soch vichar karna. This is a very important word. The more you contemplate the matter, the more are chances of you getting better ideas to do it successfully. फली नरीमन बहुत बड़े लीगल लेजेंड है. वो हमेशा कहता है कि जो मैटर होता है वो पेपर्स में कम होता है, आपके दिमाग में ज्यादा चलना चाहिए. So you have to think. The more you contemplate the matter, that is the any legal matter, the more are chances of you getting better ideas to do it successfully. Two wrongs cannot make a right. No, actually बहुत simple idiom proverb कुछ जो बोलना है बोल दीजिए आप इसको. But see how we can use it. Two wrongs cannot make a right. Wrong is wrong, and always remember, if you keep on still repeating your mistake, then better understand that the saying that two wrongs cannot make a right. Miscellaneous day. Miscellaneous day is also again a very regular word used in Supreme Court because there are miscellaneous days and there are some hearing days also. Now in Supreme Court, miscellaneous days are actually very hectic. And here we say miscellaneous application also in court, stemmed out of. Now, this matrimonial dispute stemmed out of his relation with an office staff. ये matrimonial dispute क्यों खड़ा हुआ? Because he had a relation outside the marriage. Personal feud. Now, this is again a very common word when we read the judgment. This personal feud of who is going to take care of old parents went on for long. ये आपस की लड़ाई बहुत ज्यादा समय चली. Constitute. This is again a common word we use. In Supreme Court, the Constitution bench is always formed for important matters related to national issues. जब भी national issue की बात आती है, 5 bench, 7 bench, 11 bench, आधार के लिए भी बहुत बड़ा bench है. Always remember, in Supreme Court, the Constitution bench is, there are so many judges sitting. If there is important matter which is related to national issue, arose out. This is also very common. These all cases arose out of cruelty inflicted by the husband and in-law. See the word inflicted, cruelty, and arose out of. कहाँ से आए? These all cases came out. Vague. Vague is the most common word we will be using in our legal this practice. Your allegations are so vague, जिसको कोई मतलब ही नहीं है. That a judge will not be impressed to grant you divorce. Your allegation is so vague, जिसका ना आगे ना पीछा है. There is no. We always say vague allegation without any date, details and timing. मतलब गोलमाल है, कुछ भी पता नहीं चल रहा है. Your allegation is so vague that the judge will not be impressed to grant you divorce. It is without any details. So these were few words. Whenever we do these words, please, if you are unable to write it down, I upload the video later on. You can note down these words and make your own sentences also. Or how we read Mamta Jaiswal matter today, we can take some words from there also for our arguments or for just practicing this. So this was all about today.